Thank you.
I have no complaint with the Atlanta Braves, and I'm not here to complain about the stadium project. I'm actually here because I feel I'm in defense of the Constitution of the state of Georgia. Georgia Constitution defines the role of government, state and local. It defines the relationship between the people and the government with the people in a superior position. But the Constitution gives special attention to the subject of debt by local government. It specifies, it's unusual, but it specifies that the people take direct control of debt to be issued by local government through a referendum. It specifies additional limits on debt, including a total limit on maximum debt can be incurred and also special limits in the case of revenue bonds. These limitations on debt provided by the Constitution tend to protect the interests of the people from excess on the part of government. But the law seems to have run adrift in this instance. In the case before the court today from Cobb County, we have a stadium to be built for the exclusive use of the Atlanta Braves. Cobb County and the authority have joined in an intergovernmental agreement. The authority will issue $397 million in revenue bonds. Cobb County agrees to pay approximately $19 million a year every year for 30 years, which will be derived exclusively from taxpayers of Cobb County. The Braves will pay $6.1 million per year each year. Total obligation is $25 million each year for about 30 years. The government contends that the constitutional limits on debt do not apply in this case because the government parties are working under an intergovernmental agreement. This creates what I think is a stunning and illogical conflict. The Constitution gives us protection against government excess, but the government claims the authority to negate our constitutional protections by operating under a contract with another unit of government. In this case, the government parties have created an intergovernmental agreement that exists only for the purpose of disenfranchising the voters. First, I'd like to talk about the precedent. All these cases of this type that have come through this court are built on precedent, and they invariably link back to a single case. The starting point for this line of precedent is Sheffield v. State School Building Authority in 1952. Time does not permit a complete rundown on exactly what the flaws are, but I have asserted in my brief that there are 3 errors involved in the Sheffield case. And if you're wondering, yes, I do recognize the apparent audacity of somebody who is not an attorney to come in here and allege that the court made a bad decision. I understand that.
Your view, for you to prevail, you need us to reverse, or overrule not just Sheffield, but the long line of precedents that have relied on Sheffield?
I think if you set aside Sheffield as precedent, its value as precedent, all the other cases dies with it.
Does Sheffield have to be overruled?
Yes. The determination made in Sheffield is the very root of this case, because the Sheffield case is where the court first accepted the argument that the government has an immunity to the limits of the Constitution when operating under an intergovernmental agreement. That is the underlying concept that enables this thing to even be here.
Is there any evidence that Sheffield was decided, as well as a number of other cases, before the ratification of the 1983 Constitution that we're under now? Is there any evidence that the 1983 Constitution did not incorporate our rulings on this constitutional issue as opposed to changing them?
No, not a word.
So why wouldn't we assume then that the current Constitution picks up the meaning that we had given to the Constitution before that point?
Because I think the Constitution was misread in the Sheffield case.
I guess my point is, even if we misread the 1945 Constitution in Sheffield, that's not our Constitution now. We adopted a new Constitution after Sheffield. That's the one at issue. And normally, our view has been, regardless of whether our precedent are right or wrong, if the new Constitution kind of continued, it adopted what we had explained the term to mean.
Well, the current Constitution could not be read that way. It has changed sufficiently exactly on point with where this error was made that the basis for the error has been erased. Because in the 1945 Constitution, the debt clause started out, Chapter 1, or Paragraph 1, said that the maximum amount of debt cannot exceed 7% of the market value or the assessed value of the tax digest. Paragraph 3 said you could have another 3% of debt based on tax digest, that would make a total of 10. Current Constitution simply says you can have a total maximum debt of 10%. But the problem arises with a statement in the middle of the first paragraph that says except where elsewhere described in this Constitution. That's the part that was misapplied. That is how the contracts clause, intergovernmental contracts clause, got brought into the discussion. Patch, for no apparent reason, there's not a word of explanation or direction as to how that was attached, but it was. When in fact, that exception statement refers to the third paragraph, and that's where it says you can have a 3% more than the original 7. So it's a little bit difficult to explain in a couple of minutes, but beyond that, there was an existing precedent case before Sheffield, and that was DeJarnette versus City of Albany, I believe. And in that case, the court had ruled that the introduction of the Intergovernmental Contracts Clause had no effect on the debt clause. The debt clause still applied. But Sheffield set that aside as precedent, and I'm asserting that even the argument about why it was ignored as precedent is not valid. If I read the case and read the explanation, they don't match. I cannot follow that roadmap and get to that destination. The next portion of this is the current intergovernmental agreement. The intergovernmental agreement that exists here, in my view, is not valid, and I hope that you will find that you can agree with that. This court has approved intergovernmental agreements in the past, but not every one that's ever been presented. There have been intergovernmental agreements presented here that have not passed. DeKalb versus City of Decatur, because it was an agreement on distribution of funds under a host tax. It was judged to be not a valid intergovernmental agreement. Greene County School Board versus Greene County, where there was a real estate transaction. They wanted to use as part of the bartering of the deal the revenue or the charges that the county charged the school district collecting taxes. And this court said that that was a mandated requirement, that they do that under legal mandate, and they can't barter with that as part of a real estate transaction. The court has ruled consistently that a valid intergovernmental agreement must be for joint services, provision of services, or the joint or separate use of facilities. We do not have that in this case. The entire intergovernmental agreement in this case, the authority will issue the bonds and hold the title, and the county will furnish the money to pay the bills, and that's it. This is especially troubling going forward because if this is determined to be a valid intergovernmental agreement, I think it's going to basically scratch out all the debt limits in the Constitution, because any local government in this state can replicate that intergovernmental agreement at any time. As long as they have a friendly authority that will issue the bonds, any local government with taxing power can make that deal, if that's all it takes to eliminate the effects of the limits of the Constitution.
Doesn't the authorities implementing statute give it the express power to acquire property and also to license property? And they're doing both of those things.
They are doing both of those things, but in this case, the authority's requirements, or the mandate that the authority has under the mandate the authority has under the law in which they were created is to basically build and create the projects and operate the projects, as they do in Cobb County now. They operate the Galleria Specialty Mall, they operate the Convention Center, they operate the Performing Arts Center. They have a staff of 200 or 300 people, none of which touches the stadium project. They're all walled off in the contracts so that nothing the authority normally does is connected to the stadium except issue the bonds.
Well, and license the property.
They do have the license.
It may be the authority also has the authority to operate, do construction and other things, but the statute that creates the authority says among its powers are the powers to acquire property and to license property. What's your best case for saying where the authority is doing something that it is authorized to do, an activity it's authorized to do, this court can say, sorry, that's not good enough.
Well, it's not what they're doing that they're not authorized to do, it's what they're authorized to do that they're not doing.
So they have to do everything
No, they-
listed, or we say you can do 4 out of 7, 2.5 out of 7? I mean,
What's missing, though, is they are not doing any services for the county as part of the intergovernmental agreement. That's the thing that's missing.
acquiring property and licensing property is not a service?
It's not a service worth $19 million a year.
Well, that's, this, I think we've very clearly said it's not this court's job to decide what that is worth. What standard would we use? Your standard, our standard, or the elected official's standard, if we're going to figure out whether it's actually worth
Well,
it?
that comes back to whether we're defending the Constitution or not, sir. The Constitution is not going to survive, or that portion of the Constitution does not survive any interpretation that allows this to stand as an acceptable intergovernmental agreement. All right, I'm going to have to concede